last email trailing was from Anthony Musing at the bottom of page 778. Do you see that?
Yes, I do.
Dated 14 August 2012 at 4:21 p.m. And it was directed to Mahlubi Ntlakaza and Sello Maema.
That's correct.
Are you able to explain what is contained there? What was the message?
So this email, what I gather from what's here is that it is, as you said, from Anthony Mosing to Advocate Ntlakaza and Maema. And if one notes the team earlier on, Advocate Maema is the prosecution team leader and Advocate Ntlakaza is one of the members. The subject is final Cato Manor indictment as modified by Advocate K.R. Matenjwa. And Advocate Mosing says, colleagues, herewith more corrections to the summary of facts and the memorandum. Regards. So one can infer from that that he had made corrections to the documents that he had received earlier on, under cover, as he said, of, I think it's letter dated, the memo dated 10th August that we were referring to earlier on.
Go to the one following that one on the same day, the 15th of August.
The next day.
The next day at 8:34 a.m.
So Advocate Ntlakaza responds to well, he doesn't, it's a letter from, it's an email from Advocate Ntlakaza to Advocate Matenjwa, Molochwa, Moleko, Fuchane, Maputa, and copied to Advocate Maema. These are minor changes to the enterprise only. I think we can get our certificates. I'm not sure whether Advocate Maema has printed the hard copies. I'll be at the Constitutional Court today.
So the subject there was a final Cato Manor indictment.
Yes, it's from this email. It's clear that they were preparing to get this racketeering certificate from the acting national director.
Go to the next one. That follows, it's up the page, in the middle of the page,
It's an
at 12:02.
It's an email from Advocate Maema to Advocate Mosing, Matenjwa, and copied to other colleagues in the team.
Can you read it into the record?
It states, dear colleagues, Anthony, and that would mean Anthony Mosing because his first name is Anthony, it would be Advocate Mosing. Anthony, I had a look at the proposed changes. It is more to complete the participants of the enterprise to include the Port Shepstone organized crime accused. I have worked it into the indictment at the whereases, at the summary of substantial facts, and into the prosecution memo. You asked whether we are not repeating the same paragraph at the summary of the case in the prosecution memorandum. I think it completes the introduction well and is not necessarily repetition, although it has been mentioned at the introductory part. He then goes on to say in paragraph 2, we have also added Lockham and Van Tonder as managers of the enterprise. I will make contact with you today or tomorrow to bring the hard copies. And this is important. I have also done the prosecution memo on the KZN letterhead, although our DPP, which I assume is Advocate Chauke, will sign as arranged with the acting DPP KZN. Thank you for your valuable contribution. We await your facilitation for the approval of the racketeering certificates. Remember, we require them next week. We apologize for putting you under pressure. So it was clear from that there was a lot of pressure in terms of getting these certificates authorized.
With that assumption in mind, it strikes me, Counsel, that Advocate Chauke does not appear in the list of the people who are CC'd that email.
That is correct, Chairperson. This is the team, the prosecution team at the technical level.
Am I correct to assume that at this stage, Advocate Chauke played no role whatsoever?
He's played no role in getting these documents together for the purpose of submission to the National Director. That's also an inference that I make, Chairperson.
The assumption.
Assumption.
The assumption.
I beg your pardon, not an inference, the assumption. Thank you.
Thank you, Council.
Thank you, Madam Chair. Advocate Batohi, you remember you were reading in LO1 that Advocate Molocho's tenure ended. Remember that?
Yes,
It ended on the 9th of July, if my memory serves me well. Yes, 9 July 2012, not so.
yes, that appears to be the case.
Thereafter, Advocate Noko was appointed as the acting DPP KZN, not so.
That is correct.
From memory, can you remember when she took office?
I know she was, I think it was mid-July. From memory, I think it was the 16th of July, but I stand to be corrected.
Beg yours?
I said, I think it's the 16th of July, but I stand to be corrected. It is in one of the documents.
Yes, let me refer you to a document contained in ZC 11. ZC for Zondo Commission.
Yeah, I just need to find the bundle, please. Council. It's 11.
I'm told it's in one of your
Oh,
bundles, Advocate Batohi. ZC 11. ZC 11, page ZC 02708. I will repeat it for the benefit of everyone. I'll repeat the page. Have you located it?
I have, yes, thank you.
It is a letter.
Please give me a second, Council. Page.
Page ZC 02708. It is a document prepared by the Office of the National Director of Public Prosecutions, addressed to JT Khadebe, MP.
Please give us a second to locate this document. Is ZC 0208.
Indeed, Madam Chair. Are you there?
I am.
Perhaps you must read the introductory part of that letter, because the marking here is obscured by something else. the numbering in our record is obscured by some kind of deletions.
But you got the page?
Yes, thank
If
you,
you
Council.
may read it, if you may write it by hand, maybe.
It is a document from Advocate Jiba to MP, to the Minister, I suppose. Hadebe. Is that the document?
That's the document, Madam Chair.
Thank you.
May I proceed?
Yes, sir.
Please, Advocate Batohi, read the document into the record.
The entire document. Okay, I'll go ahead.
Yes, the entire document, it's important.
Sure. It's a memorandum that is from Advocate Jiba as acting NDPP to Minister Hadebe, the Minister of Justice and Constitutional Development. It is signed by Advocate Jiba on the third page of 26 June 2012. That's ZC 2710. The subject line is request for appointment of an acting Director of Public Prosecutions, jurisdictional
I beg your
area.
pardon, Council. I'm sorry, Advocate Batohi. You said son to. Did you say son to or signed?
Signed, I beg your pardon, signed on the 26th of June 2012.
Yes, it's not an affidavit.
No, it's a
It's
memorandum.
just a memo.
That is correct.
Yes.
A memorandum from Advocate Jiba to Minister Hadebe. The subject line is a request for appointment of an acting Director of Public Prosecutions, jurisdictional area of KwaZulu-Natal High Court Division, Section 13.3 of the National Prosecuting Authority Act 1998, 32 of 1998. The purpose of the memorandum is to request the appointment of Advocate Moipone Noko Mashilo as the acting Director of Public Prosecutions for the KwaZulu-Natal High Court Division. Paragraph 2, Section 13.3 of the National Prosecuting Authority Act provides as follows. Appointment of directors and acting directors. Subsection 3, the minister may from time to time, but subject to the laws governing the public service and after consultation with the national director, from the ranks of deputy directors or persons who qualify to be appointed as deputy director as contemplated in section 115.2, appoint an acting director to discharge the duties of a director whenever the director concerned is for any reason unable to perform the duties of his or her office, or while the appointment of a person to the office of director is pending. And then below that, it says request for appointment. I think that's the subject of the memo. B is background. Paragraph 3, the minister has due to Advocate Batohi's secondment to the International Criminal Court in November 2009 and a subsequent resignation from the NPA, from the National Prosecuting Authority in April 2012, appointed various deputy directors to discharge the duties of Director of Public Prosecutions in KwaZulu-Natal, the most recent being Advocate C.S. Malochwa. Paragraph 4, to ensure adherence to the prescripts of the Senior Management Service Handbook and that no expectation is created by an extended acting appointment, I deem it necessary to request the appointment of another Senior Deputy Director to act as DPP for the period 16 July 2012 until further notice, or until the vacant post is filled. It is thus hereby requested that Advocate Moipone Noko Mashilo be appointed to act as DPP for the requested period. Advocate Noko Mashilo is a level 14 Senior Deputy Director at the DPP office in Pietermaritzburg. She is a competent, committed, and dynamic person, and I am of the opinion that she will be able to execute her duties of acting DPP. C, recommendation. It is recommended that Advocate Moipone Noko Mashilo be appointed in terms of Section 13.3 of the Act as acting DPP for the period 16 July 2012 until further notice or until the vacant post is filled. Attached, find a draft appointment for your consideration, Annexure A, and it's signed by Advocate N. Jiba, Acting National Director of Public Prosecutions, dated 26 June 2012. And below that, the recommendation, paragraph 6, is approved. Draft appointment signed, comments none, and it's signed what appears to be by Minister Hadebe on it appears to be 12th of July, 2012. I'm not sure if it's 02 July or 12 July. It's unclear. It might be 02 because if you look at the next, I'm looking at the next document, which is 02 ZC 02711. It's the appointment letter that's signed by Minister Hadebe appointing Moipone Noko Mashilo as Acting Director of Public Prosecutions for the jurisdictional area of Natal Provincial High Court Division, or the High Court, for the period of 16 July until 2012, until further notice or until the vacant position is filled. And this is signed clearly at Pretoria on the 2nd day of July, 2012, by the Minister of Justice.
Yeah, whilst you're still there, let us go back to the Act,
The
the NPA Act, National Prosecuting Authority Act.
Okay.
Go to Section 13 and confirm whether this appointment of Advocate Moipone Nokumashilo was done in terms of Section 13.
That's correct, as the memo indicates.
Now, the appointment says, for the jurisdictional area of Natal Provincial High Court Division.
Yes, that's the appointment letter that's signed by the minister.
Can you explain that jurisdictional area? What does that imply?
Well, it means that Advocate Noko Mashilo is appointed as the acting DPP for the KZN division.
Go to LO3, page LO 00665.
Before you go to that bundle, Council, what is the import of that letter that has been read into the record? The appointment of Advocate Noko? Is it merely to place on record that Advocate Mlocho was replaced?
Not only that, but it will also show subsequently that what the role of Advocate Nokumashilo was in the Katomana episode.
Thank you, Council. You may proceed.
Thank you, Madam Chair. Are you there, Advocate Batohi?
I am.
You see that there's a letter. In fact, it's an application for authorization in terms of Section 2 in brackets 4 of POCA.
That's correct.
May you kindly read it into the record?
So this is an application. It's a memorandum from on the letterhead of the Director of Public Prosecutions, KwaZulu-Natal.
Take us to that page.
00665, Chairperson.
Yes. Bundle LO3, page LO 00665, Madam Chair.
Answer? Thank you. May proceed.
Thank you, Madam Chair. May you proceed, Advocate Batohi, to read that letter into the record.
It's a memorandum from, it's, as I said, it's on the letterhead of the DPP KwaZulu-Natal. It's from Advocate M. Noko Mashilo, the acting DPP of KZN. It's dated 16 August 2012. The subject is application for authorization in terms of Section 2.4 of the POCA Act of 1998, State versus Boyson, Johann Wessel, and others. Then goes on to say the following, herewith the following. 1.1, application for authority in terms of Section 2.4 of the Prevention of Organized Crime Act 121 of 1998 for your consideration and approval. 1.2, the proposed indictment. 1.3, the draft authorizations for Section 21E and 21F, respectively. Paragraph 2 is important. It states, I have perused the documents and recommend the application. 3, accused have appeared in the Regional Court Durban, and the matter has been postponed to 24 August 2012 for the racketeering authorization. 18 of the accused persons are on bail, and 12 other accused persons will be added to the charge sheet. The name of Advocate Noko Mashilo as the acting DPP KwaZulu-Natal appears at the bottom, but the document is signed by Advocate Chauke. Chairperson, perhaps to state that this document is identical to the unsigned memorandum that was referred to earlier, which is on LO200297. And it appears from the evidence I've already tendered that after that communication between Maema and Mosing indicated that there must be a memo prepared by the, I don't have the language in front of me now, but prepared by the DPP KZN, but the email goes on to say, but it will be signed by our DPP. I assume referring to Advocate Chauke, and this document is indeed signed by Advocate Chauke. Thank you, Chair.
Advocate Batohi, are you identifying the signature appended on this page 00665 as that of Advocate Chauke?
Yes, that's correct. I know his signature, he submitted documents. On that basis, I say it's his signature.
You're referring to LO00665.
That is correct, Chairperson.
And above the name Advocate M. Noko Mashilo, there's a signature there.
That is correct, Chairperson.
Are you saying it is Advocate Chauke who signed this?
That is correct, Chairperson.
It is common cause that you took office in 2019.
The current office, yes.
Yes.
That is so.
As NDPP.
That is so.
For how long have you...
If you may remind me, why would Advocate Chauke sign and not Advocate Noko Mashilo? Because
Chairperson,
he does not seem to sign PP there.
Chairperson, the evidence that we tendered earlier, and the evidence leader will help me perhaps go to those documents, but I can paraphrase, Chairperson. What transpired from the documents we referred to is that if one looks at in bundle LO200297, there was originally a memorandum identical to this one, prepared, but in the name of Advocate Chauke for signature. The communication then between Maema and Mosing, it was Mosing, in fact, I think, who raised in one of the documents that Advocate Chauke cannot sign this memorandum because he doesn't have jurisdiction. I'm paraphrasing, Chairperson. What then happens is that there is an email which we've already led evidence on and referred to the emails that Advocate Maema, I think, writes to Advocate Mosing saying that they will prepare the document in the letterhead of KZN, but it will be signed by our DPP. So in effect, what's happening is the impression, this is my deduction, Chairperson, is created that this matter is in fact being dealt with by KZN, but is signed by Advocate Chauke as the DPP in this matter.
That's when you made an assumption that reference to DPP in that document referred to Advocate Chauke. You remember I asked you that question. When you said you are drawing an inference, and I said you are making an assumption. Is that the document?
My memory is not that great, Chairperson. I'm just trying to make sure I respond. I'm responding to the correct document.
Yes.
I do remember your question.
Yes.
But I'm just want to make sure it's linked to this and I answer properly.
In that letter, if I'm correct, Counsel, it is Advocate Maema who was writing and saying they will refer those documents to our DPP.
Yes.
And then I beg your pardon, may I finish? And then you then said, you do an inference, and I said you are drawing an assumption that DPP there refers to Advocate Chauke.
I recall, Chairperson.
Now I'm asking you a question on LO 00665, where you have that letter from Advocate Noko Mashilo, Acting Director of Public Prosecution, KZN, to Advocate Jiva. Now, the document, that letter by Advocate Musing is under his name or her name. I'm not sure whether it's a lady or it's a lady, I suppose.
It's a gentleman, Chairperson.
It's a gentleman. There's a signature there, but it doesn't appear to be PP. I would have imagined that Advocate Noko Mashilo would sign this document.
It's not her signature, Chairperson. It's Advocate Chauke's signature.
Yes. It's not PP. It's not done PP.
I can't tell, Chairperson. That's his signature.
My colleague is saying Advocate Chauke signed PP. Can you confirm that by me looking at that document?
Chairperson, he's certainly signing for Advocate Noko Mashilo. I don't know whether that's part of his signature. Whether there is a PP, whether the arrow is meant to be PP or it's part of his signature. It could potentially be a PP, but Chairperson, but it's his signature and it's Advocate Noko's name below.
Advocate Batohi, you have indicated to the panel that you know the signature of Advocate Chauke. Now, according to your knowledge, does the signature of Advocate Chauke ordinarily entail that arrow that you say you do not know? That seems to be also confusing you. Let me put it that way. Does it ordinarily entail that too?
I don't know, Chairperson. I'll have to look at another signature of his to compare. But I know that looks like his signature, and I don't think it's disputed that it's his signature, Chairperson.
Yeah, just focus on what I'm asking. I'm asking about the arrow. And your answer is that you do not know. You are going to ascertain and look at other signatures. Is that correct?
I can do that, Chairperson.
Right, thank you.
Can I piggyback from that, just for my own clarity? Why would Advocate Nokumu Singh write a letter, put his names there, and his position as the Director of Public Prosecution, KZN, and he doesn't sign the letter, and he causes someone else who is a DPP, Gauteng South, to sign?
That is an important question, Chairperson. And perhaps if we can refer back to the email, if Council will help me, this might help us understand this. The email of Maema to Mosing.
May
That
we
we,
refer to him as Advocate Maema, please?
sure, Chairperson. Advocate Maema to Advocate Mosing.
If I may assist, Madam Chair, is a lady.
I beg your pardon.
I just wanted to assist in that regard as far as
I can't hear you, Council.
I wanted to assist in regard to Advocate Muipone Nokomashilo. She's a lady.
She's a lady.
Yes.
Thank you. Thank you, Council.
If we could go to that, the email, which will help me explain, answer the Chairperson question about why would Advocate Chauke sign. If you could just direct us to that
Yes, it's in 778, LO3.
778.
LO 00778, Advocate Batohi.
Yes, thank you. Chairperson, again, it's an email from Maema to Mosing, where they are preparing the documents for submission to the National Director for the authorization or the approval of the racketeering certificates. If you look at the middle paragraph, I have also done the prosecution memo on the KZN letterhead. Although our DPP will sign as arranged with the acting DPP KZN. That will perhaps assist in explaining that, Chairperson. That's correct, Chairperson. That is correct, Chairperson.
Pardon? When one looks at the email at LO 00778, the date is 15 August 2012, and the letter that is written by Advocate M. Nokomashilo is also dated 15 August 2012. It is on that basis that you made the assumption.
That is correct, Chairperson. And if you look at the email that you referred to, it is from Selo Maema.
Yes.
And if we go to LO 00703, which is attached to the memo at LO 00665, it is signed by Advocate Maema.
It is signed by who?
Advocate Maema, the same person who sent the email that we just referred to, Chairperson.
00778.
That's correct, Chairperson.
Yes, thank you.
I have a follow-up. Advocate Batohi, if you can assist Advocate Maema, from which jurisdiction is he?
He is from, well, he's now retired, but at the time he was from the Northwest jurisdiction and was part of this team.
Northwest Division.
That is correct, Chairperson.
Now, if we say, I have also done the prosecution memo on the KZN letterheads, although our DPP will sign as arranged with the acting DPP KZN. How do we place the DPP South Gauteng in this sentence when Advocate Maema is from Northwest?
Chairperson, at the time, the evidence will show this team was put together and they were working from the VGM in the head office in Pretoria. So the team was predominantly from Johannesburg, and I'm not sure how many, Advocate Maema might have been the only one from Northwest, but they were all, they'd come together in VGM Pretoria, and they were working from the VGM office, head office, on these cases. So he was not physically at the time working in Northwest province. So he was part of the team that at the time was activities of this team was being coordinated by Advocate Chauke. So the DPP Northwest didn't have anything to do with this matter.
The VGM offices, I take it they are in Silverton,
That is correct, Chairperson. It's a head office of the NPA.
and they would fall under the jurisdiction of Pretoria.
That is correct, Chairperson. The office is in Pretoria.
So the DPP there would be DPP Pretoria.
The VGM is in the jurisdiction of DPP Pretoria. That's correct.
Okay, Batohi, I'm trying to make sense of the use of our DPP and marry it to Advocate Chauke. If you can assist me with that link.
Sure. Chairperson, the understanding is that there was a team that was put together. And if we look at paragraph 60 that we referred to earlier on, that sets out the team.
Yes,
Is that 60 of
no, in Advocate Chauke's witness statement.
if we could just be directed to that part, I will be helped to answer the question better. Because what practically happened is that prosecutors from Johannesburg, and this is my understanding, and I'm sure there'll be others that will be better placed because, as I said, I was not here at the time. I'm gathering from other bits of evidence, so it's not my direct evidence. But my understanding is that this team was put together. If we can be directed to that paragraph and the page number, it will help. But my understanding is that this team of prosecutors working on this case were working from the Pretoria of the VGM office under the DPP Gauteng, that South Gauteng, that is Advocate Chauke, and dealing with these cases that actually emanated, this particular case emanated from KZN. That is my understanding of how this worked.
May I refer you, therefore, for purposes of understanding and for purpose of answering Madam Baloyi-Mary's question to paragraph 60 of LO1 on page LO 00266. Just to recap, you have already dealt with it, but for purposes of answering the question, it is appropriate that you should go back to it. It's in LO1, Madam Chair, and the page is LO 00266. And if I may point out, my colleague informs me that it's almost lunch break.
Yes, I've noted that. I just want us to wrap this aspect so that we don't forget where we ended. Is at LO 00266.
That's correct, Madam Chair.
paragraph 60.
Paragraph 60 thereof. This is a witness statement of Advocate Chauke that served before the State Capture Commission.
Yes, that he was asked by Advocate Jiba to put together the team.
Indeed, Madam Chair.
He says, according to that paragraph 60, Advocate Chauke states, Jiba requested me to assist with putting together a prosecution team which will guide members of the police and members of IPID, the Cato Manor team, on the investigation and prosecution of the matters. I agreed to be the coordinator of the prosecution team. The prosecution team was comprised of the following advocates: Advocate S. Maema, DDPP, team leader. Now he was at the time, my understanding is, I'm not here, and Advocate Chauke will be able to better testify to this, a DDPP in Northwest, but working now as part of this team, the team leader, in fact. Advocate Matenjwa, DDPP, my understanding is that he was based in Johannesburg at the time. Advocate Ntlakaza, I'm not sure which division he was from. Advocate Molochwa, I think was also from Johannesburg at the time. Advocate Fushane was from Johannesburg. And Advocate Moleko, I don't know from which division.
Whilst you're still there, let me interpose. When you refer to Advocate Molochwa, make a proper distinction between this Molochwa and the Molochwa in KZN.
That is correct. They are not
Yes.
the same. They are different persons.
This one is
Different people.
This one is referred to as Advocate JJ.
Yes, that's
Molochwa.
correct. The other one is Simpiwe Molochwa.
And the document on page 665, the memorandum that you referred to earlier, which was signed by Advocate Chauke, together with the documents attached thereto,
So
Have-
665 on which bundle?
LO3, the
Yes.
the memorandum of 15 August
Yes.
signed by Advocate Chauke,
Mhm.
have an impact on paragraphs 3, 3.1, 3.1.1, 3.1.1.1, and 3.1.1.2 of the terms of reference. Can you confirm that?
That's correct. And I should mention that the second paragraph, which states, I have perused the documents and recommend the application. The applications to the National Director for Racketeering are submitted by the Director of Public Prosecutions from the jurisdiction where the case emanates, which is normally the case. And the DPP must be satisfied that there is sufficient evidence to support the application and then would recommend the application, Chairperson. And in this case, it appears that Advocate Chauke is recommending the application. Whether it's on behalf of Advocate Noko, I think she needs to explain, but that's the position.
Perhaps to answer the question by my sister, Advocate Baloyi SC, a very pertinent answer could be at LO 00267, paragraph 62, 62.4, Advocate Mutlamuyane, where it reads, this is Advocate Chauke speaking, 62.4, and correct me if I'm wrong, feedback and briefing on the team to Jiba, including the submissions of documentation from the prosecution team to the NDPP.
Yes, that's correct, Chairperson. It would be consistent with this.
Yes, thank you. So it makes sense why then on this issue that we have been wondering about as to why Advocate Chauke signed, he tells us in his affidavit in the volume 1, LO 00267, that it was his role to make sure that those documents were then forwarded to the NDPP advocate Jiba.
That is correct. It's in line with that. But the important part being that he recommends the application, which a DPP would normally do, in whose jurisdiction the matter resides.
Yes.
Thank you, Chairperson.
Thank you. Thank you, Council. I think this is an appropriate time to take a lunch adjournment. It's 1:45. We will adjourn now and reconvene at 2:30.
Thanks, Madam Chair. We'll do that.
Yes, thank you. We'll adjourn for lunch until 2:30.
Chairperson and your sisters and everybody else. Advocate Batohi, Madam Chair has referred you to when we adjourned, just before we adjourned for lunch recess, to LO1, paragraph 62.4. Paragraph 62.4, LO 00267, that's the page. We remember? Yes, 267. I'm going to ask you a very pertinent question regarding this sub-paragraph. And my question is, what Advocate Chauke is stating in this paragraph, has it to do with a prosecutorial decision or a prosecutorial? Has it to do with a prosecutorial decision?
Sorry, can you?
What,
I'm not clear about the question.
what Advocate Chauke states in this paragraph, has it to do with him taking a prosecutorial decision?
Is that
Is-
paragraph 62.4?
62.4.
In paragraph 62, Advocate Chauke sets out what he says his role was as team coordinator. And in 62.4, he says it included feedback and briefing to the team, including the submission of documentation not on the face of it, it's just submission of documentation. But if you submit documentation where you recommend prosecution or recommend the authorization of racketeering charges, that is taking a prosecutorial decision. And when Advocate Chauke signed the document we are referring to earlier, I don't have the reference now,
LO3 on page 665.
he was in fact taking a prosecutorial decision to recommend charges on racketeering to the national director.
Which goes to the root of paragraph 3.1.1
That's correct.
of the terms of reference.
That is correct. And there will be various other prosecutorial decisions that we will identify in the course of my testimony. Chairperson, if I may, we did check the signature of Advocate Chauke. It does not have an arrow in the ones we've checked.
My understanding, apart from the signature, was that 62.4 of LO 00267 might do the trick to answer why, instead of why Advocate Chauke signed instead of Advocate Noko.
Chairperson, I'm not sure what you mean by might do the trick. My
Well,
apologies.
The point was that what we asked you was, why is it that the letter is signed by Advocate Noko?
Which letter, Chairperson?
You remember the letter is 26. Is it 265? Advocate Mutlamuyana, 266. 265. Let's check that letter again. Is it 265?
LO. Let me just. 665, Madam Chair, if you are referring to that one, which
665.
bears the names of Advocate Noko Mashilo.
Yes. we asked you several questions about why Advocate Noko Mashilo did not sign that letter herself. And you said that the signature looks like the signature of Advocate Chauke.
That's correct, Chairperson.
And I asked further, if that is the case, why didn't he sign PP? Because he is signing as the DPP KZN when he is not.
That is correct, Chairperson.
And then we went through the record, and a letter, or rather the affidavit of Advocate Chauke, in paragraph 62,
Yes, Chairperson.
he explains his role there as the coordinator of the team.
That is correct.
And he explains that 62.1, what he did, 62.2, what his role was, 62.3 exclusion, that he was not taking any prosecutorial decision, whether to prosecute or not, and 62.4, he then explains that it was his responsibility to give a feedback and briefing on the team to Advocate Jiba, including the submissions of documents from the prosecution team to the NDPP.
Correct, Chairperson.
Which seems, and I emphasized, which seems to support the proposition that he signed that letter following what Advocate Maema said.
That is correct, Chairperson, because it includes submission of documentation. So that is correct, Chairperson. But the same document, before we move off it, that's 665, doesn't support what he says in 62.3 as not excluding prosecutorial decisions, because recommending a racketeering charge is taking a prosecutorial decision.
Recommending a prosecutorial charge in
Racketeering in this instance.
In the letter.
That is correct.
That he purportedly signed. He said that he took that decision. He recommended.
He does. Paragraph 2. I've perused the documents and recommend the application.
Let's unpack that. A recommendation is a recommendation. A decision, taking a decision per se, is a decision. Am I correct that the two concepts and the legal meaning thereof might differ? In other words, you recommend for someone to take a decision.
I understand, Chairperson. In the context of prosecutions, a DPP, when there is a case that involves racketeering, and the DPP then makes a recommendation to the national director, the DPP cannot take a decision to prosecute racketeering without, it's the national director's authority. But when a DPP recommends a prosecution, that DPP is taking a prosecutorial decision to recommend the prosecution. In that sense, you must be satisfied that the evidence supports your recommendation. And prosecutorial decisions, there's a range of decisions that prosecutors take in the course of a prosecution process that are prosecutorial decisions. And in this case, although it's a recommendation, it is a decision to recommend, a prosecutorial decision to recommend to the national director, and also saying that by saying I have perused the documents and recommend the application, you are satisfied that there's sufficient evidence to support the application. So that is the distinction, Chairperson.
my mind, let me clear my mind. My understanding is that following the request by Advocate Jiba to him, Advocate Chauke, to coordinate the team,
Mhm.
his involvement was to that extent as a coordinator of the team. But we do know when you look at that list that you referred us to earlier, of all those advocates from different jurisdictional areas, including Advocate Mayema from the Northwest,
Mhm.
who was the head or the lead prosecution, the lead of the prosecution team.
Mhm.
How then do we suggest that Advocate Chauke could take a prosecutorial decision when he is merely a coordinator?
Chairperson, Advocate Chauke says he's merely a coordinator, but the evidence does not bear that out. And if we refer, it's Chairperson said, and I hope I'm correct, Chairperson, you mentioned that Jiba asked him to coordinate. But if you look at Advocate Jiba's affidavit that she made, and I would ask the leader of the evidence to guide me in that regard, because I don't have it here. I think that will make it clear what Advocate Jiba's view was, that he was not merely a coordinator, that he was in fact the de facto DPP. The DPP in charge are the words that she uses in that affidavit. If I can be guided so that we can direct the panel to that particular aspect. And my point being, Chairperson, Advocate Jiba in that affidavit states that Advocate Chauke is the DPP in charge of this matter. And that's important to understand his role.
I'm not sure what it means. That may be open to different interpretations. When you say he is the advocate in charge, it could mean many things.
Chairperson, the evidence will guide what that can mean, and that will emerge from the evidence that will be placed before the panel.
And the evidence of Advocate Musing to the effect that Advocate Chauke was a coordinator, a mere coordinator, seemed to support his view that he was not involved as a decision maker, prosecutorially and otherwise, or otherwise.
I'm not sure where Advocate Mosing said that, but if that is what he said, he would definitely be supporting Advocate Chauke's case in that regard.
Yes, we'll look at the page, and if you look at Advocate Mosing's evidence, I'll pick up that page.
Sure.
Counsel, I'll pick up that page and refer you to it later. You may please proceed so long.
May I just come in here? From your evidence and maybe also from the law, the Director of Public Prosecution does not have the power to institute action or criminal action relating to racketeering. The furthest, I want to understand exactly what your evidence is. Is it your evidence that when it comes to racketeering, the Director of Public Prosecutions can only go as far as to make a recommendation to the NDPP, and the power to then take the matter further lies with the NDPP? Is that a correct understanding? If not, please correct me.
That is a correct understanding.
Now, when you say that Advocate Chauke was exercising the prosecutorial power when he wrote, or rather, when he signed this letter that was addressed to the NDPP, the one that is at LO3, page 665. Maybe I should draw your attention to paragraph 2 of that letter in particular, which reads, I have perused the documents and recommend the application. Now, recommend in the sense and in the context of this letter, would you see it as a recommendation meeting the threshold that you are talking about, the threshold of the director making a recommendation to the NDPP, or what is your understanding?
So the first point would be, I didn't say it's a prosecutorial power. I said because that is not the power that the DPP has in respect of racketeering charges. I said that it was a prosecutorial decision that was taken by Advocate Chauke. And that's important because Advocate Chauke says if we go back to it, he did not take prosecutorial decisions. And in this case, the point is that making a decision that there is sufficient evidence in a matter to recommend a prosecution to the national director is a prosecutorial decision. And there are various other kinds of prosecutorial decisions that we take during a prosecution process.
So just to have a clear distinction for my own better understanding, the distinction between the prosecutorial power and the decision to make a recommendation. You would say the directors of public prosecutions do have the power to decide whether to prosecute or not to prosecute in respect of many other crimes, to the exclusion of racketeering. Is that correct?
That is absolutely correct.
That's fine. Thank you.
If I may, Counsel, just to follow up on that proposition that I made earlier, that the evidence that you submitted as annexures to your affidavit, the opinion of Advocate de Kock. If you look at the record, your annexure SB 3132, the internal memo to you from Advocate RJ de Kock and team of 27 June 2019. It appears as SB 3132, your annexure. If you look at page SB 3138, paragraph 12, it speaks to the delegation of powers, where Advocate de Kock and team suggests that there was a delegation and authorization issued to the prosecution team that was constituted by those people: Advocate Maema, Advocate Mtenjwa, Advocate Ntlakaza, Advocate Muleko, Advocate Mlochwa, Advocate Putani. And Advocate Chauke does not appear there. Then read paragraph 12 in conjunction with paragraph 13, where Advocate Musing is referred to by Advocate Kock. There it reads, Musing states that his understanding of Advocate Chauke's role was that he was, open quote, merely to manage the team as they were mainly from his office, but will not be vested with any decision-making powers regarding prosecutorial decision. Now, if you read this part with the delegation paragraph, because I assume for Advocate Chauke to assume that role, the prosecutorial role in KZN, powers should have been delegated to him, as they did with the team of Advocate Maema. Am I correct?
Chairperson, that is correct. And the way that could have been done is if he was appointed acting DPP for KZN.
So bring your attention to those amendments.
Mhm.
That actually, I beg your pardon, I was drawing your attention to those amendments in the pages referring to what Advocate Kok says in the opinion referring to Advocate Musing and the delegation of the powers to the team, excluding Advocate Chauke.
Thank you, Chairperson. That's what Advocate Mosing says his
Yes.
understanding was of Advocate Chauke's role.
That said, what then do you make of this paragraph 12 and 13, where there's a delegation to a specific group, excluding Advocate Chauke, and the authorization to prosecute to this team, excluding Advocate Chauke, and then Advocate Musing, according to Advocate Kok and his team, state very clearly that Advocate Chauke merely managed the team, but was not vested with any decision to make a prosecutorial decision. What should we make of that?
Chairperson, paragraph 12 is clear that, and I don't have the evidence before me about, but clearly if we accept Advocate de Kock's report, and we have no reason not to, and his team, this team mentioned were issued with delegations and the necessary authority to prosecute a case because all of them were from outside KZN. So my understanding is that there is a provision in the Act that allows the National Director to issue delegations to prosecutors to prosecute in a jurisdiction outside where they are stationed. My understanding is, and I stand to be corrected, is that normally, well, I understand this. This is not what, well, let me be clear. Normally, if a prosecutor from one jurisdiction is and I speak about a prosecutor, not a DPP. A prosecutor from one jurisdiction prosecuting a matter in another jurisdiction is not uncommon. I wouldn't say it happens, but when that happens, the prosecutor that goes to the receiving DPP, let's call it that DPP must issue the prosecutor delegation to prosecute in his or her jurisdiction. My understanding is that the NDPP has a similar power to issue delegations to prosecutors. So in this case, whether it was the DPP, but there's no evidence to suggest that, or the National Director, but that's understandable. They were issued with the delegation. So they were properly delegated, although the case is something else, but they were properly delegated to prosecute outside of the areas that they were stationed. With regard to paragraph 13, Advocate Mosing states his understanding was that this was Chauke's role to merely manage the team. But the evidence will suggest that that was not his role and that he was in fact the de facto DPP leading this team and in fact taking prosecutorial decisions.
If that were to be the case, it means you are presenting to us contradictory evidence.
In what sense, Chairperson?
In the sense that Musing says one thing and you say there's another evidence that presupposes that Advocate Chauke was vested with the prosecutorial decision-making.
Chairperson, I am not presenting that evidence. The evidence is there in the docket. I'm leading the panel to evidence that demonstrates this in documents.
I may be wrong. Are you probably drawing an inference, making an inferential reasoning from the entire evidence, or there is a specific evidence to that effect?
Chairperson, I'd say there's specific evidence as well as an inference from all of the evidence when presented.
Inferential reasoning.
But there is specific evidence, and that's the evidence that I referred to is Advocate Jiba's statement, where she says that Advocate Chauke is the DPP in charge of this matter. And that shows he was the DPP in charge of this matter. We can try to find out what in charge means,
Yes.
but I think the common understanding is in charge is you are the one responsible for this prosecution. That's my understanding, Chair. But that is direct evidence from Advocate Chiba.
Yes. With regard to paragraph 12, I would imagine that if the delegation was supposed to have included Advocate Chauke, it would have been easy for Advocate Jiba to include his name, purely on the basis of the principle inclusio unius exclusio alterius. I'm trying to figure out the right English interpretation. The inclusion of one is the exclusion of the other. The inclusion of one is the exclusion of the other. Right?
Chairperson, I'm not sure that I follow your question. I want to answer it correctly.
When you make a list of things and then you include certain things and then you exclude the others, that principle kicks in, that you decide to include a group, and that inclusion means there's an intentional exclusion of the others. Am I wrong?
Chairperson, in this, you're not wrong on the principle. But Chairperson, in this regard, Advocate Chauke was appointed specifically as DPP in Gauteng. He could not exercise his powers as DPP in any other division.
No, I understand that. I understand your evidence around that.
Mhm.
What we are doing now, we are unpacking the facts that you are presenting before us to make a determination around those two bigger issues, whether he is fit and proper to hold office. Now, when we unpack that, it takes us to things like paragraph 12, whether he was indeed vested with the power to prosecute or not to prosecute. Now, what I'm saying is when the list is made where power is delegated, you would imagine that everybody to whom the power is to be delegated will be included in that list. And
Understood.
anybody who does not appear in the list means it was an intentional exclusion of that person. Because delegation is critical here. You don't just go to somebody's jurisdiction and exercise powers. You ought to have been delegated to do that.
Understood, Chairperson.
Yes. Now, paragraph 12 tells us subsequently delegations and authorizations were issued to the prosecution team that was constituted as follows. And it names those people, but excludes Advocate Chauke. And
That
that's
is
where
correct.
I am.
That is correct.
Thank you, Council.
Just once more. Just, I'm trying to settle this issue of jurisdiction, trying to distinguish between the Director of Public Prosecutions on the one hand and the prosecutors on the other hand. I'm struggling to do that, and I know you will assist me to understand that better. Is the understanding, maybe let me start off this way. Let's talk about prosecutors just for a short while. The prosecutors get appointed by who is it the minister who appoints the prosecutors?
The minister appoints deputy directors of public prosecutions. That is the one level below a DPP. The level from DPP upwards are presidential appointments. The minister appoints deputy DPPs and chief prosecutors. They are on the same level. The one level below that, which are then your senior state advocates, it's not the minister, and it would be, I don't know whether it's the DG that appoints, but the ministerial appointment is only at the deputy DPP level.
Right. Do you know whether prosecutors are appointed for specific jurisdictions, or what is the position?
Yes, they are appointed in specific jurisdictions.
So for them to migrate to another jurisdiction, be it, I think temporarily in the context of this matter, would that require, whose authority would be required to authorize that temporary operation from a different jurisdiction from the one which the prosecutor would have been appointed for?
If that scenario happens, then what would normally happen is the two DPPs would speak and they would agree that a prosecutor from one division will go to the other division to assist or to prosecute. In that event, the DPP of the receiving DPP will have to issue a delegation there that gives that prosecutor the power to conduct a prosecution in his or her jurisdiction.
And finally, would the NDPP have the power to delegate the director of public prosecutions?
Chairperson, I seem to think there's a provision in the Act that allows for that. Perhaps the evidence leader can check and correct that, but I could be mistaken. I have not done that in my term. I can't recall having done that. But I think there is a power. We can correct that.
Yeah. Would you like the evidence leader to give you the relevant
I would appreciate
legislation
that, Chairperson.
so that you can refer? I wouldn't want him to be giving evidence.
I would appreciate that, Chairperson.
That is the NPA Act.
That is correct, Chairperson.
You don't have it with you.
I do have it, but I need to be referred to the section, if there is one, that in fact confers such a power to the NDPP. Otherwise, I need to go through it to check if it is there. So,
yeah. So what I'm trying to avoid, you are saying it would rather be done that he then give information on the relevant enabling provision.
if there was one, if they direct me to it, then I can
Okay.
testify to that effect, Chairperson, whatever it might be.
Chair, through you, may he just do that.
Yes, Council, are you in a position now to assist with the relevant provision of the Act so that Advocate Batohi can reflect on that? If not, your colleagues can flag that aspect, and then later, when they are ready, including Advocate Haile Adebeg there, then we can then revisit this aspect. Is it possible to do that?
It's not
Unless
possible.
if you are ready now.
No, I'm not ready now to refer her to the specific section in the Act.
In that event, I
But-
think, I beg your pardon.
Thanks, Madam Chair. The questions that have been posed to you, Advocate Batohi, brings into sharp focus in our quest to unpack the issues here, brings into sharp focus as to what exactly is a prosecutor. And that's where I want us to start. a prosecutor is defined in the Act. Let's go to the Act and get a definition of a prosecutor before we get to your concern.
In the definition section.
Definition section, yes.
Just may I just come in here, please? Are you on your way to enabling the witness to settle this issue that I have about the jurisdictional point, the distinction between directors of public prosecutions and the prosecutions? Is it
Indeed.
the route there?
I'm on my route to there, Madam Ramachaka.
Okay, thank you. Then you can proceed.
With the help of my colleagues about the specific section, but I'm on my route to that because it is important, Advocate Batohi, that we should understand what is a prosecutor. Is a DPP a prosecutor?
Not in terms of the definition in the Act.
Just a minute, hang on. I'm sorry to interpose. The unpacking of these issues, as I indicated, brings into focus what is a prosecutor? How does a prosecutor, how do you compare a prosecutor with an NDPP? What is the role of a prosecutor vis-a-vis a DPP? Let's go to the definition section then, and kindly read the definition section of what a prosecutor means.
So a prosecutor in section 5.
No,
No, it's
before.
not so. It's in the
bef-
definition section.
Yes,
sorry.
go to the first.
Chapter
Let's
1,
start.
section
Yes.
1. Prosecutor means a prosecutor referred to in section 16.1. Then
Let-
if we,
Let's go to 16.1 and hear who a prosecutor is and what is a prosecutor.
section 16.1 states, prosecution shall be appointed on the recommendation of the national director or a member of the prosecuting authority designated for that purpose by the national director, subject to the laws governing the public service. Prosecutors may be appointed to the office of the national director. Two, prosecutors may be appointed to A, office of the national director, B, offices established by section 6.1, and that's the DPP offices, C, investigating directorates, and D, lower courts in the Republic. Paragraph 16.3 states the minister may from time to time, in consultation with the national director and after consultation with the directors, prescribe the legal qualifications for the appointment of a person as a prosecutor in a lower court. 4, insofar as laws governing the public service pertaining to deputy directors and prosecutors may be inconsistent with this act, the provisions of this act shall apply. Having said that, I want to correct something that I said earlier on when asked about the appointment of prosecutors, and I mentioned the DG. The DG doesn't have a role in appointing prosecutors. The HR functions are with the minister, but the minister can delegate those functions. So I just want to clarify that, and I'm not sure where it's delegated to, but we can check that in terms of who appoints below the level of DDPP.
Go to section 20 of the NPA Act. 20 subsection 5. Read it because it deals with the competencies of a prosecutor.
It reads, any prosecutor shall be competent to exercise any of the powers referred to in subsection 1 to the extent that he or she has been authorized thereto in writing by the national director or by a person designated by the national director. And if we go to subsection
6.
1, sorry.
You want to go to subsection 1?
No, just to explain subsection 5, because it refers to the powers in subsection 1. And those are the powers that are listed there: to institute or conduct criminal proceedings on behalf of the state, to carry out the necessary functions incidental thereto. I'm not quoting verbatim, and to discontinue criminal proceedings.
Thank you. To answer Madam Ramahaka's concern and question, I'm informed by my colleagues that there is no provision in the Act, in the NPA Act, where a National Director of Public Prosecutions can delegate a DPP to another jurisdiction. It's not provided for.
Is that the case? Do you confirm what the evidence leader is placing on record?
Chairperson, if I could have a look later, and then I'd be happy to confirm that at a later stage. I will discuss with my team, and I'd like to check. I'm under oath, and I want to make sure that that's the correct information. I have no reason to doubt them, but I want to make sure.
Yes, Madam, I think it is proper to take that posture. Advocate Mutlamunyane, you may be entering the zone of argument, legal argument, with the position that you've just made, because the very evidence you are talking about is the evidence that your client, or rather Advocate Batohi, has presented to us. The DCOC documents are part of her evidence. And it is that evidence in paragraphs 12 and 13, whether it is in line with the law or not, the fact of the matter is that it is the evidence that Advocate Batohi presented to us. We will deal with the veracity of that evidence probably later if a need arises, remembering that we are on the fact-finding process. So I suggest that we don't get into legal argument. Let us concentrate on the facts.
Chairperson, may I clarify something?
I beg your pardon,
May I
madam.
clarify?
Please wait a minute. Let counsel confer with Advocate Mutlamunyane.
This question is raised by concern. It's concern delegation of organization to Chauke. There was another. So in this case, so the only delegation in which we give delegations to all the other cases from part of the prosecution to all the from the public. But yeah, I'm not sure. But talk about the message of all the other cases.
I will proceed with the question.
We are having different conferences in this space. I think we will have time to revisit these topics at a later stage, because I'm not sure what the right answer is, but we are guided by the affidavit of Advocate Batohi together with her annexures. We are working on that evidence as we are clarifying few aspects by asking her questions.
Chairperson, if I may clarify something on
Yes,
that
ma'am.
aspect, because it
Yes.
is my affidavit, and I'm listening very carefully to what you're saying. I want to explain that my affidavit, firstly, was drawn up at very short notice. We were under tight timelines. There may be things that are in here. There may be things that are not in here that should have been here. But of course, we tried to be as precise as possible in the very short time space that we had. To explain that the annexures to my affidavit are not necessarily my evidence. I want to explain what I mean by that. I explain the process that in my affidavit, I explain the process leading up to the referral. And in that process, if you bear with me for a moment, Chairperson, I'm just trying to find my affidavit. I have it right in front of me. In the process, which is on page 69 of my affidavit, I have set out what the steps I took leading up to the referral. And I mentioned the various legal opinions that I received. So that is not, it's attached to my affidavit as opinions that I received. And Advocate de Kock's memorandum is one of the is a report that I received from the team. And because I refer to it in my affidavit, I have attached all these documents for ease of reference for the panel. There may be parts of it that I may not agree with. There may be parts of the annexes that I agree with, but I wanted to clarify that. Thank you, Chairperson.
Well, of course, it is so that these documents formed part of the documents as a result of which you formed a prima facie view when you referred the matter to the president.
Chairperson, let me explain that because it's important for the panel to understand. I received these opinions. When I received Advocate Nalane's opinion, which is referred to in this process and is an attachment, I then sent that document, this is all set out in my affidavit, to Advocate Chauke and asked him to respond to that. He then submitted Advocate Maineche's report, which is also attached to this. As a result of those two legal opinions, it was clear that there were gaps in evidence. And I emphasize those are opinions. There were gaps. And so I then asked Dr. Broughton in my office to get all the evidence and then to prepare an opinion to me. He initially prepared one opinion, which I gave him just a week to do it, and it was too short notice. He came back to me and said he needed more time because he needed to look at a whole range of documents. He then provided me with a supplementary opinion. But that supplementary opinion, in my view, is almost like a forensic analysis of the evidence, because together with his opinion, he provided me a bundle of evidence. And my decision to recommend to the president was based primarily on the evidence that was provided to me, attached or forwarded as annexures to Dr. Broughton's opinion. So I want to be clear about that because the others were opinions that I considered, but when I made the decision, I looked at the documents, many of which we are presenting now. Some of that may not be presented, but I will speak to council about the entire bundle being handed in as evidence because that is what I based my decision on, looking at actual documents, statements, etc. I hope I've clarified, Chairperson.
Yes, and I think you repeat what I'm saying, but in different words. In other words, when you made a referral to the president, these very documents were part of the initial bundle.
That is correct, Chairperson.
In terms of which the president had to consider your request.
That is correct, Chairperson.
And these documents assisted you, all of them, assisted you in formulating a view whether to refer or not to refer.
They certainly assisted me, Chairperson, but I do want to emphasize that I looked at the underlying evidence, and that was the main. I came to a conclusion based on my own analysis of the underlying evidence together with the opinions.
You may proceed, Council.
Thank you, Madam Chair.
My apologies.
I heard you earlier saying VGM, and
My apologies, Chairperson,
I
baby.
don't know what is VGM.
It stands for the Victoria and Griffiths Mthenge Building, which is the name of the NPA head office in Pretoria. VGM is Victoria and Griffith Mcenge. That's the short form acronym for the name of the building, Chairperson.
Thank you. Thank you, Madam Chair. Perhaps it is an opportune moment, Advocate Batohi, to, whilst unpacking issues, explain to the ordinary person what racketeering is. So that it should be clear why prosecutors acted in the manner in which they did. What is racketeering? How
So,
Pick, Council, please pack it there. I just want to finalize a niggling issue concerning the role or the alleged role of Advocate Chauke in KZN. Assuming for now that Advocate Chauke did participate in the prosecutorial decision making, in terms of which he would have then entered the jurisdictional area of another DPP, something that the law prevents unless certain prerequisites are adhered to. Am I right?
indeed, Madam Chair?
Would you please deal with that aspect as to what is it that ought to have been done if we assume that indeed Advocate Chauke, as Advocate Batohi is saying, did participate in the prosecutorial decision making. This is just a proposition that need not be correct, but it's on the assumption that what he says is correct, then what ought to have happened as a requisite or a prerequisite for doing that, leaving Gauteng, South Gauteng division, going to KZN division to do that? What does the Act requires?
Madam Chair, that can be explained by Advocate Batohi, and maybe the law provides for that. But I was of the view that because we are dealing with very serious offenses, or an offense called racketeering, I should start there so that racketeering can be explained as to what it is, and the seriousness thereof, before we could get into the issue of whether another DPP can get into the area of one DPP can get into the jurisdiction of another DPP.
In other words, I ran ahead of you.
Indeed, Madam Chair.
Thank you.
You preempted me.
Along those lines.
As it pleases, Madam Chair. Advocate Batohi, may you explain what a racketeering offense is? It's a very complex offense. What does it entail? Bearing in mind what was earlier read into the record as far as the law is concerned on racketeering.
so I suppose you don't want me to give you the legal definition, in which case we have to go to the Prevention of Organized Crime Act and deal with the legal definitions. You just want me to explain in layperson's terms what racketeering means.
Start with the legal definition and you
So
can go to the layman's term.
We will need to go to the Prevention of
Because-
Organized Crime Act then, if I could. I don't have that in front of me. If I can be directed to the Prevention of Organized Crime Act, if we want the actual provisions of the law.
We'll make a plan that you get a copy.
We can deal with that later.
Yeah.
Thank you, Chair.
For now, explain it in layman's terms. What is it?
Thank you. So racketeering is basically a charge where the prosecution needs to prove that there is an enterprise. That means there's a group of people that are associated, in fact, or it's a particular entity that can be identified, and that they are engaged in a pattern of racketeering activity. And it's not very easy to describe it in layperson's terms, but it means that this group has together engaged in various types of criminal activities, are the predicate offenses, and that they worked together in order to achieve the objectives of that group, which is normally a criminal objective. But various people in this group have various roles. For example, you could be a manager, you could participate in the enterprise. And so there are various parts of the act that criminalize various activities. And so in a nutshell, it's a group of people working together to achieve a criminal outcome, and engaging in various types of criminal activities.
I think, Counsel, I see Advocate Haley's junior counsel. You can come closer, madam, and assist Advocate Batohi with documentation that she might need.
Thank you. I have the prevention of organized crime, but is it okay if I went without, I don't know if the panel has the act in front of them. Should I proceed, Chairperson? I'm guided by
We
you.
do have our act somewhere in our bundles, but we may proceed and subject to what counsel says. If it is necessary to read verbatim what the act says.
It's just brought me to the first page of the act, and I need to go through it so that I can get to, I think it's section 2 that deals with the offenses. Okay.
Counsel, is it what you want the witness to do? To go through section 2 of the POCA?
I'm going. Chairperson, sorry.
Maybe for current purposes, we may revisit it at a later stage if the need arises. Just read section 2 in brackets 4 into the record.
Sure. Section 2, paragraph 4. Well, it's chapter 2. Section 2 deals with the offenses. 2.1, I'm trying to get to 2.4. It's 2.4. 2.4 deals with the authority of the national director. Says a person shall only be charged with committing an offense contemplated in subsection 1 if a prosecution is authorized in writing by the national director. That's section 2.4.
Leave it at that for now. We can come back to it. But in your bundle, Advocate Batohi, Advocate Dikog and his team deal with racketeering offenses. They explain it at great length as to what they entail.
That's correct.
Let's park it for now. Let's leave it at that for now and continue with your evidence. But they deal with it on page 215 of SB3 under subparagraph E. They deal in extenso with what racketeering is all about.
Yes, that's correct. from paragraph 212.
I want to
Well,
refer you to
I think that, sorry, before we move on, paragraph 212 deals with the particular cases. I'm not sure whether it deals broadly with what racketeering is about, but I'm sure.
yeah, let's park it for now. It's all right. It's okay. Whilst you are dealing with prosecutorial decisions as to what exactly constitute prosecutorial decisions and the role of Advocate Chauke, may I draw your attention to LO 3, page LO 00782. And may I mention, Madam Chair and your sisters, that the document I referred the witness to is a document of dates of meetings, page 00782, LO3 bundle. This is a document prepared by, I should believe, by Advocate Chauke, in which he was indicating his role and the meetings he had with IPIT, SAPS, and the judiciary until August 2012. Are you there, Advocate Batohi?
I'm getting there. Just
782, Madam Chair. Now, it impacts on the TOR paragraphs 3, 3.1, 3.1.1, 3.1.1.1 of the TOR. Now, please read that document into the record.
So, Chairperson, if
To read the entire document, which is quite a long, from 782, dates of meetings with the prosecution team of Katumena and briefing with acting NDDP, as well as meetings with IPID, SAPS, and judiciary until August 2012.
Let me direct her attention to specific dates without reading the whole document. Start with the 3rd May. Read the heading and go to 3 May 2012 at 1300 hours.
yes, if I may, Chairperson, this appears to be an annexure, and Council will guide me. At 781 is an email from Advocate Chauke to the team, to various persons. And it says, "Good day to all. Here with dates of meetings and briefings I have recorded in my activities diary. I hope it meets with all that is required from me to extend that I was involved in the Cato matter." And then it appears that that is attached to that affidavit, to that email.
Yes, you're correct. You're correct. Proceed then to, the email was directed to the Katomana team. Is that correct?
Yes, it appears so.
Yes. Now start with the 3rd of May.
Amongst others, the acting NDPP is also copied in there. It's addressed to her as well, and others. I should say it also appears that the DPP of KZN is also CC'd at its Moipone Noko. I see her name there as well. and this is the date of this email is 30 September 2015.
May.
Should I read that?
Start with the heading.
The heading is dates of meetings with the prosecution team of Cato Manor and briefings with acting NDPP, as well as meetings with IPID, SAPS, and the judiciary until August 2012.
Read the entry of 3 May.
3rd May 2012, it's the first entry at 1300 hours. Meeting with Advocate Jiba, re Cato Manor matter, arranged for briefing for 18 May 2012 at 800 hours.
Read the second one, 22 May.
22 May at 20:20, meeting with Brigadier Mokwena, in brackets Hawks, Mr. Angus, IPID, Maema, Ntlakaza, Moleko, Mlochwa, and Fuchane, Matenjwa in court.
Go to the 24th.
At 8 a.m., briefing with acting NDPP at Pretoria with the whole prosecution team, Cato Manor, Advocate Matenjwa doing the briefing, category of dockets, sub 1, conspiracy to kill members of Kwa Maputo Taxi Association, 2, conspiracy to kill ATM bombings syndicate, 3, conspiracy to kill criminal gangs, security for the prosecution team, SAPS National Office, delegations, protection, Part 8 of Prosecution Manual and Section 17 of Inquest Act 58 of 1959 also discussed.
Go to the next one, the 4th, 29 May 2012.
At 1500, Cape Town, briefing with Minister of Justice and acting NDPP, need to prepare the draft indictment and finalize the allocation of a judge to preside over the matter. Need to speak to South Gauteng DJP or JP of Gauteng.
Go to the 11th,
At 13,
June.
11 June at 1300 hours, meeting with Mr. Björkman of IPID and Matenjwa.
Go to the 18th June.
June at 2012 at 1200 hours, meeting in Durban Magistrates Court with Cato Manor prosecution team.
Go to the next page, 784, 00784.
18 June at 1400 hours, meeting with acting NDPP and AJP, that's acting JP of KZN, in Pietermaritzburg regarding Cato Manor matter.
Go to the 20th June, the second 20th June.
At 1600 hours, Durban High Court urgent application for release of arrested Cato Manor members, application dismissed and referred to regional court.
Go to the next page. Go to the entry of the 6th.
6th of August 2012, meeting with Cato Manor team, editing the indictment and memo to acting NDPP.
And we say, Madam Chair, that this has an impact on the TOR, specifically paragraph 3.1.1.3.1.1.1.
Chairperson, this, in addition to other evidence, will show that Advocate Chauke was not just a coordinator. He was deeply immersed in this particular prosecution.
Go to the 8th August.
8th of August 2012, 1800, Cato Manor indictment preparation and arranged to brief acting NDPP.
Proceed. The second, 8 August.
At 1100 hours, VGM, that's the NPA head office, briefing session with the acting NDPP Jiba, re Cato Manor and certificate of centralization.
Go to the 9th.
We will explain that in due course, the certificate of centralization. The 9th, Durban at 1500, 9th of August 2012, Durban KZN briefing with Moipone Noko, acting DPP KZN at 1800 hours.
Go to the 10 August. There is no time specified there.
Meeting with KZN JP and acting DPP and handed draft indictment to him, memo to be sent by acting DPP on Monday, 13 August 2012.
August, the second one.
Meeting with acting NDPP rebriefing regarding misconduct hearing and prosecution policy in Cato Manor matters.
Go to the next page. 786. 24 August.
Durban Regional Court appearance of General Boyson and others re Cato Manor matter.
That is all, Madam Chair, as far as that is concerned.
Just a minute. And these to which term are they relevant?
I indicated
You read the first batch and now, or is it just one continuous list? Okay.
it's one continuous list, Madam Ramakaha.
Okay. Thank you.
Advocate, if I may ask, all these entries that you were referring us to from LO 00782 to LO 00786, and you said they tied with the terms of reference at 3.1.1.1.
Indeed, that is so.
We've had evidence, well, at least corroborated by Advocate, is it Musia or whoever? Mosing, that Advocate Chauke played a role of a liaison between the prosecutorial team in the Cato Manor and the acting NDPP. Now, these entries, these meetings, these briefings that are mentioned here, do they in any way result into Advocate Chauke taking a role of a prosecutor or taking prosecutorial decisions? Or this is just a licensed person giving regular briefings on behalf, because in other instances he says he's with the whole team or he's alone or whatever, but can we clarify that? The witness clarify that.
Maybe I should not be seen to be testifying from the bar. The best way is to ask the witness to clarify that. To the extent to which you can, Advocate Batohi, can you clarify the role that Advocate Chauke is indicating in this document?
Well, in this document, as it purports to be, dates of meetings and briefings. And there's no indication in this documentation that there's any prosecutorial decisions that are taken. It's just a list of meetings and briefings. There is indication that Advocate Chauke is involved in activities that go beyond mere coordination. For example, if you look at the 6th of August meeting with the team, editing, that's not just a coordination function, that's getting involved in the memo would be a prosecution memo which would contain evidence in the matter. The 8th of August at 8 a.m., indictment preparation. Likewise, that's not simply a coordination function. And we'll deal with the centralization certificate. There is evidence that will be led about that shortly. The evidence leader will decide when to take me there. But certainly, well, I should change what I said earlier. I said none of them refer to taking prosecutorial decisions. I should change that. This particular one, that is the signing of a certificate of centralization. Let me explain first, perhaps, Chairperson, what a centralization certificate is. I had explained earlier, but I'll refresh our memories. This is where there are various offenses committed in different parts of the country, and the national director, upon application by the two, well, depends, if let's assume it's in 2 provinces, the DPPs of the 2 provinces would apply to the national director for a centralization of these matters into one area, for better management of the case. The taking of a decision on whether to centralize or not is a prosecutorial decision that the DPP will take in consultation with the others in terms of where the case should be heard, which jurisdiction, etc. Those all relate to taking prosecutorial decisions, and a decision to apply for a centralization certificate from the national director would normally be made by the DPP who has jurisdiction over the matter. So I leave it at that for now. That is the way the centralization process works.
Does the NDPP get involved in the centralization process?
The NDPP authorizes the central.
Authorizes.
That's correct.
But maybe as a follow-up, because these notes are very cryptic. For example, where you talk about a certificate of centralization, we are not sure whether it was what was the purpose, what was happening with the certificate of centralization. Was Advocate Chauke, had he approached the acting NDPP to apply for a certificate of centralization, or they were just discussing the centralization? Well, it is so cryptic that one cannot make head or tail of exactly what was happening here.
Yes, Chairperson, these are Advocate Chauke's notes, but there will be evidence that he did indeed apply for centralization.
Thank you.
Thank you, Madam Baloimere. Maybe we should hasten at this moment to go to Dr. Broughton's supplementary affidavit, which is LO1. I beg your pardon, it's not an affidavit, it's an opinion. It's a slip of the mind. I said affidavit, Dr. Broughton's affidavit.
It's his opinion, yes.
Yes. It's in LO1. Direct your attention to page 188, LO00188. Madam Chair, you've located the page is LO00188 in bundle 1. LO1 to be specific, LO1. I direct your attention, Advocate Batohi, to paragraph 55. May you read paragraph 55 into the record. You may not read the whole of it, but read the first sentence and we'll take it from there.
Okay, thank you, Council. You'll tell me when to stop.
Yeah, I'll tell you when to stop.
Sure.
Read paragraph 55.
It is further to be noted that Advocate Chauke made an entry in Annexure J, and Chairperson, this would be Annexure J to his opinion, that on 6 August 2012, he had a meeting with the Cato Manor team, editing the indictment and memo to acting NDPP, in quotes.
Wait a minute, just allow me to interpose there. If you refer back to LO3 bundle, LO 00786,
Yes, that's the
where Advocate Chauke held meetings with various authorities. Is that what, on the entry of 6 August, it says editing the indictment. Is that what Dr. Broughton was referring to?
Yes, that appears to be the same meeting that is being referred to in this paragraph.
Yes, proceed to read.
Advocate Chauke thus records that he is involved in the preparation of the memorandum and the application for racketeering authorizations. Annexure E, that's to his opinion. In the very next entry dated 8 August 2012 at 800 hours, Advocate Chauke stated as follows: Cato Manor indictment preparation and arranging for brief acting NDPP. Again, Advocate Chauke was recording his involvement with the preparation of the application for racketeering authorizations, Annexure E in brackets, to be submitted to Advocate Jiva. Advocate Chauke then records that on 8 August 2012 at 1100 hours at VGM, he had a briefing session with the acting NDPP, Jiba, regarding Cato Manor and certificate of centralization. Advocate Noko was not involved with that, even though she was supposed to be the DPP responsible for the Boyson prosecution. However, Advocate Chauke then made the entry that on 9 August 2012 at 1800 hours in Durban, he had a briefing with Moipone Noko, acting DPP KZN. This is the first time that Advocate Noko features in or is mentioned in the attachment of Annexure J. Advocate Chauke does not state what the nature of this briefing with Advocate Noko was. There is no mention that he provided the Boyson Cato Manor case dockets to her. The very next entry records that on 10 August 2012, Advocate Chauke had open quotes, meeting with KZN JP, an acting DPP, and handed draft indictment to him. Memo to be sent by acting DPP on Monday, 13 August 2012. Advocate Chauke does not state what memorandum was to be sent by Advocate Noko on 13 August 2012. It is to be observed also that Advocate Chauke records that he handed the draft indictment to him, which must be referring to the Judge President of the KZN division. Should I continue?
Continue.
The impression is created that Advocate Chauke was in charge of the Boyson prosecution and Advocate Noko was simply on the periphery to give a veneer of legitimacy to the process that it de jure did not have. The question arises why Advocate Chauke was involved in this process of filing the indictment with the KZN High Court. Surely the Boyson prosecution team, in terms of their special delegations, were required to be reporting to Advocate Noko, through whom the indictment was supposed to be filed. Should I continue, Council? Although we do not know ex facie the attachment, what the memorandum was to be submitted by Advocate Noko relating to the case, it speaks volumes, like with his affidavit to the State Capture Commission, Advocate B, that Advocate Chauke is silent in the attachment as to the events of 15 August 2012 with regard to the signing of the covering letter with the recommendation of the application for racketeering authorizations, Annexure E.
you may hold it there. This then takes us to the affidavit of Advocate Noko.
Advocate?
Noko.
Okay.
It is contained in bundle LO1 on page LO00241.
Sorry, LO24. Sorry, can you repeat that, Council?
241. May I proceed, Madam Chair? Thank you. It makes interesting reading. May you read it into the record and explain under what circumstances. This is an affidavit by Advocate Noko. May you read it into the record, Advocate Batohi?
It's an affidavit by Advocate Noko. It appears also in the Silverton CAS number, which is unclear. Paragraph 1, I am the Director of Public Prosecution in KwaZulu-Natal, Division of the High Court of South Africa. My ID number is, I won't mention it for current purposes, Chairperson, and residing at Durban with my office at 301 Church Street, Pietermaritzburg, High Court, Pietermaritzburg. I won't mention her cell phone numbers, Chairperson, that are included here. Paragraph 2, my mandate as the Director of Public Prosecutions in KwaZulu-Natal in terms of the NPA Act 32 of 1998 and the Constitution of the Republic of South Africa 108 of 1996. Paragraph 3, since the Cato Manor case came into being, I have not been directly overseeing it as the DPP. I have not been directly overseeing it as the DPP until around March or April 2014, when the National Director of Public Prosecutions, Mr. Nkolisi Nkasana, instructed me to start directly overseeing the case. This instruction was given during a meeting when the prosecution team was briefing him on the developments of the case. Before this instruction, the Director of Public Prosecution, South Gauteng Division, Johannesburg, Advocate Andrew Chauke, was directly overseeing the case, and he also supervised the prosecution team, and they also reported directly to him as far as the case is concerned. 4, the prosecution team was established before my involvement and the following advocates are part of the team: Advocate Maema, Advocate Matenjwa, Advocate Nslakaza, Advocate Moleko, Advocate Mnochwa, Advocate Fushane. I'm just using the surnames. Paragraph 5, during August 2012, while I was the acting Director of Public Prosecutions, KwaZulu-Natal, I was requested by Advocate Chauke, DPP South Gauteng, to sign a covering letter to a prosecution memorandum intended for the NPA head office. I signed this covering letter as procedure, being the acting DPP where the matter is pending, but not directly overseeing the case. DPP South Gauteng was. The matter is still pending in the KwaZulu-Natal High Court in Durban and is sub judice. The matter appeared in this High Court again on 30 March 2015 and further postponed to later during this year. Paragraph 6, 7, that is all I want to say, and then the oath follows.
Next page. She signs it.
Yes, I beg your pardon.
What date was it?
Well, it appears to be her signature. I'm not sure. I can't recognize her signature.
No, I mean the date.
The
There appears.
date is the 31st of March 2015.
Yeah, she makes mention in her affidavit, specifically in paragraph 3 of the National Director of Public Prosecutions, Mr. Nkabinde Nkasana. To interpose, maybe we should find out as to when Mr. Nkasana took office to clarify this.
I don't have the precise date when he took office.
We are having it here. It's written to us here. I'm being given a document which says Advocate Mxoli Sinkasana was appointed with effect from the 1st October 2013 and he vacated office on 14 May 2015. I'm sure this will not be in dispute.
I have no reason to doubt the correctness of that.
Now, what you have read here is given on oath by Advocate Noko pertains to paragraphs 3, 3.1, 3.1.1 of the terms of reference. Not so?
That's correct.
Madam Chair, we will now proceed to centralizations. It will become clearer as to what exactly a centralization is. Go to page, let me see, 781.
Council, just give me a second, please. Advocate Mutlamunyane, it's 4:05 on that watch in front of me. Are you going to be long on this aspect? Or would you like, if it's going to be long, it will probably be better to defer it until tomorrow. But if it is a matter that can be disposed of quickly, then we can deal with it.
It cannot be easily disposed of as quickly as we would have loved. Maybe it's appropriate to leave it and roll the matter over to tomorrow morning.
We consider then that this is an appropriate time to adjourn. You'll take it from here with regard to Advocate Ngasana's assumption of office. And we will begin at 9 o'clock tomorrow morning. If council can be here to meet us for 5 minutes, around 8:45, we so propose. In that event, Advocate Batohi, we will take an adjournment until tomorrow morning at 9 o'clock. We adjourn.